attorney's fees. Now, that's a topic that doesn't sound very dramatic, but a recent court decision has suddenly brought into question the ability of co-op boards to charge back legal fees in shareholder disputes and more. This could be hugely consequential for co-ops. So today we're going to explain what happened and what your board's options are now.
At the Folsom Group, our mission is to help boards make smart decisions every day. From end-to-end property management searches and construction project management to cost optimization, we help boards achieve sustainable savings, on-time projects, and long-term performance that speaks for itself.
I'm Carol Ott with Habitat Magazine, and joining me today is Bill McCracken, partner at Moritt Hock Hamroff. Welcome, Bill.
Hi, Carol. How are you doing?
Good. Let's set the stage for those of us who aren't lawyers. First of all, explain what are attorneys' fee provisions, where they're spelled out, and how do they normally work in a co-op case?
Okay, sure. And I'm going to try not to get too weedy, but some of this can get a little weedy.
Okay.
So I apologize in advance to your viewers, but stick with us because we'll get there. But to answer your question, you often have in contracts of all types, you have attorney's fees provisions or prevailing party provision, where and most relevant here is if the parties get into a dispute, then the parties agree ahead of time that the winning party will be entitled to their attorney's fees reimbursed by the losing party. That is something that needs to be in contracts because the default rule in this country, unlike in some other countries, is that everybody pays their own attorney's fees and you bear your own costs, and it's not included as part of your victory in the litigation. So if you want to have that, which is useful for people who think that they're right to be able to shift attorney's fees to the other side, then you have to put it in your contract. And so a proprietary lease is a contract like any others, but it's a lease for a co-op apartment building. And like many residential leases, there are attorney's fees provisions in there. And the one that we're focused on today is one that was originally drafted by landlords, naturally. And then landlords naturally wanted to make it as advantageous to landlords as possible. So they put these sort of one-sided attorney's fees provisions in their proprietary leases, saying that if we have to sue you because you're in default, we can recover our attorney's fees in that litigation, right? So if you stop paying your rent or you start, doing things that you're not supposed to do under the rules, and I have to go to court and sue you as the landlord, as the co-op, then I can recover my attorney's fees. The issue became that people thought that that wasn't fair, that tenants don't have the bargaining power to get their side. If they go into court and they win, that they should get their attorney's fees reimbursed. And so at some point, many years ago, the state legislature passed something called Real Property Law 234, which said, in effect, that all of these landlord-friendly attorney's fees provisions, if they don't have the ability for the tenant to recover as the prevailing party, then we're going to just imply it as a matter of law. Anytime there's a landlord-friendly prevailing party provision, attorney's fees provision in litigation, if the tenant wins, they get their attorney's fees back from the landlord. And so it was an attempt by statute to even the playing field for these attorney's fees provisions.
So let me just ask, in proprietary leases now in co-ops, is that language which basically says whoever wins gets their attorney's fees paid for? Is that language in all proprietary leases?
Well, there's in every proprietary lease I can think of, there is some language like that. And the traditional form from the 1970s, the one that you've seen 1,000 times in a proprietary lease, it doesn't actually say anything about being a prevailing party. It says that if there's a defaulting shareholder and if the landlord, the co-op, incurs legal fees in suing that shareholder, then they get their legal fees back, right? And so there's a premise in that attorney's fees provision, or this is how we've always read it, that it requires a sort of prevailing party concept because there's a defaulting shareholder. It's not just, I sue you and I get my attorney's fees. I sue you because you have defaulted. And therefore, if I'm the prevailing party, I get my attorney's fees. And under RPL 234, the tenants were protected. So if they prevail, they get their attorney's fees. But in the typical classic proprietary lease, it's not really spelled out too clearly. And that actually became a problem because when people look at these leases and they're trying to make them more clear and give shareholders and everybody else more guidance as to when the co-op might be able to recover attorney's fees, they start expanding that classic form and try and add things to it. You know, if I have to send a letter because your apartment's leaking or, you know, you're making too much noise, it doesn't go to litigation. Do I get to recover my attorney's fees then? What if instead of when I sue you for non-payment of rent or for making noise or whatever, what if you just sue the co-op one day out of the blue, and shouldn't I get my attorney's fees back in that situation as well? And that's actually what happened in this most recent case is the Dakota building, and everybody knows the Dakota on 72nd and Central Park West, most famous apartment building in the world, most famous co-op building in the world. They had one of these classic sort of bare bones attorney's fees provisions. And at some point, someone realized that, you know, we should add into that provision that if you sue the co-op, then we should get our attorney's fees provision in that as well. The problem is, and I guess we can get to the case shortly, but I don't want to go too far, is in drafting that language, you have to be very careful. And it turns out that the court thought that they weren't careful enough in how they drafted it.
So talk about the Dakota case, because that apparently has sent ripples through the legal community.
Sure. Yes. And in fairness, the Dakota case, it's Kasowitz Benson versus JP Morgan Chase. It has a very odd posture. Kasowitz Benson was the firm that was representing a former board president who tried to buy an additional apartment in the Dakota and was turned down, sued the board for racial discrimination, and the board racked up over $2 million in legal fees, but were successful in the case. They were successful in the case. So they were the prevailing party. So they sent that shareholder a bill for the $2 million, I think it's $2.4 million in the legal fees that the co-op had incurred in successfully defending this litigation. No problem, right? Like you're the prevailing party. I should get that. So the thing that happened in this building is that this shareholder had other debts as well. He had a loan, a co-op loan on his apartments in the Dakota, and he stopped paying his loan payments. And then JP Morgan Chase defaulted him under his loan documents. And as everybody knows, probably watching this interview, is typically a co-op has a first lien against a shareholder. So meaning that if you owe the co-op money and you owe the bank money, the co-op gets paid first. That's by statute. That's very well established. And the bank was scratching their heads trying to figure out how they were going to get any money out of this guy when he owed the co-op $2.4 million. And so they came up with an interesting strategy, and a successful one ultimately. They rely on a case that had been decided a few years ago that your magazine talked about at the time as being problematic. It was called the Crodell versus Amalgamated case, where that co-op had again drafted a new sort of form of proprietary lease and had included all sorts of circumstances in which the co-op could get their legal fees reimbursed. But because it was so broad and because the way that case unfolded, basically that co-op board under their lease became entitled to their attorney's fees, even though they weren't the prevailing party. You follow me?
I do.
You had a circumstance under that lease whereby even though I don't win under the lease, I'm still entitled to get my attorney's fees back, which seems unfair. And that's what the court said. The court said, look, it's all fine that you have this attorney's fees provision, but it is actually against public policy for you to be able to recover your attorney's fees in a situation where you didn't actually prevail? Like, why, how could you have a situation where the tenant's just sort of standing up for themselves and asserting their rights, and they're still obligated to pay the co-op for the trouble? It doesn't seem right. And so they threw out that entire attorney's fees provision as being unconscionable. And so when that decision came down, that was in end of 2018. Again, there were articles in Habitat Magazine talking about this is a problem, but it was sort of, people looked at it because that particular lease was a little bit unusual. They weren't necessarily the prevailing party, so it seemed like there was a sense of fairness there. This case is different in the Dakota case because the co-op did prevail, right? Clearly they won. They had a total victory. The prop lease provision was not that unusual. And so it came as a big surprise that it got struck down. And it got struck down. The bank argued that it was unconscionable under that prior Crudell case. And the reason why is when the Dakota had amended their proprietary lease to add in a little proviso that if you sue the co-op, I get my attorney's fees then as well. What they forgot to do, according to the court, is they forgot to make it clear that if you sue the co-op and lose and the co-op wins, then the co-op gets to recover its attorney's fees. All it says in the amendment that they did is that if you sue the co-op, we get our attorney's fees.
Regardless of
who wins. And when they did the amendment to the shareholders of the Dakota, they were explaining that this is only intended to apply when you are the prevailing party. And that's why it's okay to adopt this amendment, shareholders. But if you look at the language, and the court looked very closely at the language, it doesn't actually say that in that particular amendment. And so the court said, I don't care that you actually won. You still have the same problem with this provision, which is that there are circumstances in which even if you were in the wrong, co-op, and the shareholder sues you and is trying to enforce their rights, and they're right, under your proprietary lease, you could have a claim against them for attorney's fees. That's not fair. That's against public policy. And I'm throwing the whole thing out. Even though in this particular case, they had $2.4 million that they prevailed on. Now they're in a situation where they can't recover that. And the bank jumped in front of it. And they now have effectively the first lien against that shareholder.
Okay. So this was in one case. Practically, how will this case affect the co-op community? And broadly speaking, many co-ops, it's one thing to have a lawsuit against a shareholder. It's another thing where we as a board ask our attorney to write a letter to the shareholder saying, you owe us money, or you're behind in arrears, or you're annoying or something.
Right. So I think there are two things to say about that. And this probably would be the big takeaways for anybody watching. One is all of these decisions have to do with what happens in a litigation between a co-op and a shareholder. None of these cases really deal with that problem that you're talking about when I have to write a letter or there's a dispute that doesn't go to litigation. So I would say that none of these cases directly affect those circumstances. That doesn't mean that there might not be an issue with those, but I can't set, nobody's saying that, because the Dakota building, the Kazowitz case has been decided the way it was, now you can't charge back a shareholder when I write them a letter. Not saying that. At least that's not what the court said. However, the second part of this is anybody who reads the Kazowitz decision or the Crodell decision before it, they need to ask their lawyers, look at our attorney's fees provision. Are there circumstances under which, under our lease, we could become entitled to recover attorney's fees, even if we are in the wrong, right? Even if we're the bad guy and we're in default, are we still entitled to charge attorney's fees back to the shareholder that we're in a dispute with? Because in that case, we may have a problem.
In your experience, are there many proprietary leases that would have language like that?
So I would say that the classic proprietary leases, the bare bones attorney's fees provisions, I have to think that they are safe under the new regime because they've always been safe. They haven't ever been declared unconscionable or against public policy. But particularly if you've redone your attorney's fees provision, or if you've expanded it over the years, that's when you have to go back and look at it and see how carefully that you drafted those amendments. I have seen prop leases, and we've done them, that try to have like a savings provision in the attorney's fees provision that says, notwithstanding anything else in here, we only recover our fees if we're the prevailing party, right? Or if the shareholder is in default, to try and cover that concern that the courts have expressed about fairness. We're not actually trying to charge back a shareholder legal fees when we're wrong, right? Like, we're not. But that's what I would say. Like, I certainly think it's something that to be concerned about, but I don't think that it means that every prop lease in the city, or even most prop leases in the city, are now not going to be enforceable for these attorney's fees provisions.
And just remind our listeners, if the board pulled up the proprietary lease and realized that particular section needed to be amended, the procedure to do that is what?
Well, that's what the big problem with all of this is, because if it was just as simple as fixing it, then you could just fix it. But amending a proprietary lease is usually very difficult. You usually need a supermajority, at least 66 2/3 of the shareholders, to approve an amendment to the proprietary lease. And even when you're doing something relatively routine, like extending the term or what have you, it can be expensive and time consuming. You have to educate the shareholders why you're asking for it. Some of them won't vote. Some of, they just won't bother. And it can be a very difficult process to get any sort of prop lease amendment passed. And certainly one where, you are telling the shareholders that I can charge you back money under these circumstances, it might be a tough ask. So that's the answer. It is usually a supermajority of the shareholders, and that's not easy.
And so looking forward, if you had to leave board members with one takeaway, and there's a balance here that you have laid out, what would that be?
So yes, the takeaway mainly is, if you're concerned about this issue, send your prop lease to your attorney and tell them exactly this. Are there circumstances under which the co-op would become entitled to legal fees, even though they weren't either the prevailing party or the non-defaulting party? And if there are circumstances that could come up that raises a question of fairness, then I need the attorney to advise me what to do next.
All right. Thank you very much. It sounds like great advice. I'm Carol Ott, and this has been Bill McCracken. Thanks so much for listening.